Folks, we're back. This is Steve Sanson, Stephanie Phillips with another episode of Veterans in Politics. Today we have Kristine Brewer, candidate for Clark County District Court Judge, Family Division, Department S. But before we get to Ms. Brewer, Ms. Phillips.
Thanks for joining us, everybody, and thank you to our sponsors. We have Dr. Ari Nagy. He's running for Congressional District 3. His website is nagyforcongress.com, and that's F-O-R, nagyforcongress.com. We also have Henderson's mayor, Michelle Romero. She's running for re-election. Her website is votemichelleromero.com, votemichelleromero.com. We also have Cody K. Whipple. He's running for Congressional District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. We also have Dave Marlin. He's running for Las Vegas City Council, Ward 6. His website is daveforvegas.com, and that's F-O-R, daveforvegas.com. And we also have Jennifer Schwartz. She is running, what is her Department 17. Sorry, Jennifer. Judge Schwartz, running for re-election, Department 17. Her website is judgeschwartz.com, judgeschwartz.com. And don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant in family court and you can't afford an attorney and don't have one, you're going to want to grab this book. It's a self-help book. It will help you navigate that system. You can get a copy on Amazon. It is $14.99. Also, we have a merch store. It's VIPImerch.com, VIPImerch.com. There's all kinds of fun things for you to check out there. And also, we have our endorsement interviews, our judicial endorsement interviews beginning this Saturday and continuing for the next 3 Saturdays. And you guys are going to want to jump on our endorsement, joint veteran endorsement Facebook page. And these are going to be live streamed so you can watch them and see who we endorse. Also, for my rant real quick, I have been I've been seeing all of these documents that have been coming out from the Epstein files. And the more I read, the more sick to my stomach. I'm sure you guys have read a lot of them as well. They get more demonic and more evil with the more I read. And when Trump said, I think it was last week, he said, now that we have all the files released, now we need to move on. No, President Trump, we don't. We heard that someone say, I think they said Pam Bondi said it, and then I heard she didn't say that. But if they prosecute all these people, the whole system will collapse. Well, so be it. If that happens, let it collapse. Let it start over. Anyone who is involved in any of this deserves to rot in prison and in hell, actually. And it is so disgusting what these people have done. So President Trump, no, these people need to be prosecuted. These survivors, they deserve justice. So it isn't just we release the files and we're going to move on. That's not what this is. These people need to go to prison.
Amen to that.
So I always agree with President Trump. I think he's doing a great job. I have voted for him 3 times. But when he said that, I did not like that.
Isn't one of the things you read that they took a 5-year-old female?
Don't even repeat what I said to you because it was so graphic what I read. It literally turned, and I read some more this afternoon. It literally turns my stomach. It really does. It affects me. It's so disgusting. So yeah, a 5-year-old. Yeah.
Whew. All right. Thank you, Ms. Phillips.
Anyway, sorry about, part of my rant.
Ms. Brewer, thank you for coming on the program.
Thanks for having me, Steve.
Absolutely.
And Stephanie.
Could you give us a bio, please?
Yes, I have been in Las Vegas since 1972. And I'm the oldest of 5 children. I went to our local schools, OK Adcock, Garside Junior High, Bonanza, and I graduated from UNLV with a degree in political science. I went to the University of Utah for a couple of years before I graduated from UNLV. And my dad owned a couple of 7-Elevens here in the Valley And I actually worked at Dad's 7-Eleven. In the summers, he'd take me, and I loved running the register and cleaning up the aisles and helping him with doing the accounting. And when I was in college, I finished up college at UNLV and worked there for 3 years, helping Dad out. So it gave him a little breathing room, and I got to learn about business and customer service and, our community. It was very nice. And I was a swimmer, a competitive swimmer. I swam on the Las Vegas Sandpipers in the 70s, yes. And Las Vegas Gold and the lesser known Rapids. And my siblings were also swimmers, and all 5 of us were coached by gold medal winner Rowdy Gaines.
Okay.
So that was fun to, get to meet him and know him and swim with my siblings. And it was at the Doolittle swimming pool that Rowdy coached at, which is now indoors, I believe. It was outdoors when we swam there.
Oh, wow.
Yeah. So he kept us hustling in the water so we stayed warm.
Mm-hmm.
So you're a good swimmer?
Pretty decent, yes.
Could you swim better than the Navy SEALs?
Heck no. They're the ultimate in, breathing techniques. Wow. I admire what those men, and I think one woman has passed the Navy
there
SEALs.
been? Really?
I think one may have tried.
Oh, maybe so.
Talking about G.I. Jane. So could you hold your breath?
I could, when I was swimming competitively, I could do 50 meters with no breath.
So you're running for family court.
Yes.
Congratulations.
Thank you.
Why family court?
Because I have been practicing family law since 2004. That has been the focus of my legal practice. And I have a sincere, true passion to assist the families in this community, and especially the children, because the children are our future, and they're, what make families tick sometimes. They're the most important thing in the world, children.
Okay.
And I believe that I can assist families by helping them through the most difficult times of their life. And I've done that as an attorney for going on now I'm in my 23rd year.
Okay.
As a family law attorney. That my practice has been focused on that in all aspects: custody, divorce. I've done guardianship, adoptions, and a little bit of juvenile dependency and name changes. Whatever family court does, I've touched on it at least a little bit, if not a lot.
Which one is your strength?
I would say my strength is in child custody.
Okay.
Absolutely. And I really, I read the best interest standards whenever I have a child custody case. I go through those standards and how the facts of the case apply to what our statute says in NRS 123B0035. And, how it's very fact driven. And even I go beyond what the statute says. Is there anything else that's relevant? Anything. Sometimes it could be schooling. Sometimes it could be, the connection to the community, or maybe the child, medical conditions. Anything else. I like to think outside of the box. Right. And I believe our statute does have the breadth to look at that.
So you've run before.
Yes, I have.
What are you going to do different this time?
I am committed to more social media and to more outreach. And I also hired campaign managers, which I believe is a true huge step in the right direction, because that is helping me stay on track. Because I really love getting out in the community, and, meeting people where they're at, going to whether it's a school, an opening, the different chambers in our community. I've enjoyed what I've done, and I'm looking forward to meeting more of the people out in the Clark County community during this run.
What is the best way, do you think? Because I always ask judges and candidates as well. No one knows who the judges are. No one knows who you guys are. What is the best way to connect with people? Is it door to door? Is it, planning events? What's the best way to get to the people?
I believe it is in my day-to-day interactions. I communicate with the folks at the grocery store if I'm getting gas. I believe that it's my duty to reach out to the community and let them know who I am. Mm-hmm. And it sparks conversation. And I think it's exciting. So I believe, if I'm at the courthouse, I've had beautiful interactions with the public and the community at the courthouse and been able to connect. And it's just by reaching out. When I see a grandmother who's crying or someone who doesn't know where their courtroom is, just taking a moment and having that interaction, because I think it really matters to hear people, to see people.
Mm-hmm. There's a lot of people out there that say, this judge hates women or this judge hates men, and they're biased towards mom or dad or one or the other. We hear that a lot from litigants. As a judge, how are you going to be balanced to where you're not biased towards one or the other side?
That's a really great question. I believe that I will bring my listening skills to the bench. God gave me 2 ears and 1 mouth. So I'm going to keep my ears open and listen and really hear the litigants, because each litigant has a story, both parties sitting before me, and to listen before rendering a decision, to make sure their voices are heard, because they're individuals. And I believe that it's very important for people in our community in Clark County to have their voices heard by the judges.
Good.
That's a good one. Let's talk about pro se litigants that doesn't have legal representation. How would you go about handling those?
I have had the opportunity to have cases where the other side was not represented. And I treat them with the same dignity and respect that I would an attorney. And I believe that having litigants in front of me, I will ask them questions and do my best to help facilitate resolution if possible. And I have had the opportunity to watch various judges on the bench do that. And prior to COVID, we could sit in the courtroom easily. I believe our courtrooms are more open now, which I like. And if I'm down at the courthouse, I do like to sit in the courtrooms and watch the judges and see if I can help the parties find common ground, because facilitating resolution is going to save time and aggravation and help, these people in our community get on with their lives. And this is such an important issue. Family court, our families are, in my opinion, the most important thing that we have in our lives.
Do you appear more via Zoom or do you appear more in person for your clients?
I would say I appear more in person for my clients. Mm-hmm. Yes.
It makes a difference, doesn't it? Isn't it more effective when being there with your client? Because I've witnessed both and watched both. And I think we share that opinion where when that attorney is not there, it's just not the same. I don't think.
You know what? I feel that the judge can see my facial expressions and my client, and I can see them. And I feel like we have an interaction, like we're having a conversation here. When I'm in the courtroom, I am having a conversation with the judge, and I am presenting my client's position. And I do believe I do believe that our judges do the best that they possibly can, not to prefer or give an edge, because Zoom does create a way that people who may have transportation issues, they may have work issues, because it makes access to justice. So I do believe there's a balance. However, my personal opinion is I feel like it's more effective when I'm in person, and I enjoy that interaction, because it's easy to accidentally or talk over the judge or talk over the other counsel when I'm on Zoom and they're in person. So I do like the courtroom.
You feel at home in the courtroom?
I do. Absolutely.
What should the public expect from you regarding courtroom transparency?
I believe that our courtrooms are open, and that means, that if visitors want to come in, they should, and they're invited. And I also believe that it's a great way for people that have upcoming cases, come visit the courthouse. I would welcome that. See the inside of the courtroom so it feels familiar and not so scary when it's your case. And, where you're going to sit and what to expect. I would absolutely welcome that. And I do believe it's important for the public to have access to the bench. And, when we go to court, like I just shared, it's nice to sit in the courtroom and see what's going on with, the judge and the other part of the calendar. And it's not just good for me. Guess what? It's good for my client. And my client's the one who's going to have the judge render a decision. So they feel more comfortable if they can sit in there for a couple of hearings before their hearing. But I would welcome, as a judge, the public coming in. Anyone will be welcome.
Have you ever appealed the judge's decision?
Have I appealed? I have not handled a lot of appellate work. My husband, who I practiced law with for many years, he did some appellate work at our firm. So that was not what I did, but my husband did, and it was successful.
So he's a lawyer as well?
Yes, my husband is.
Does he have his own law firm?
No. We did practice together from about 2009 to 2016. And
practice together?
Yes.
That's a long time to be in business with the husband.
Yes, it is. We decided.
How was that role?
You know what? When it's good, it's very good.
Mm-hmm.
And when it's difficult, it's difficult. And we decided that we wanted to stay married, jokingly. And so we we went to different firms.
Do you want to end up in family court? You don't want to end up in family court.
True.
So you went to different companies.
Yes, we went to different law firms. And you know what? It was a great growing experience professionally for both of us. Mm-hmm. And then, believe it or not, sometimes we talk about what's going on, new Supreme Court rules or new 8th Judicial District Court rules. And that might be a full dinner conversation.
Right. So what role should mediation play before the case reach trial?
I believe that Nevada law does say that if you have children, you must go to the Family Mediation Center, mm-hmm. because it is preferred under the law that the parents come together because they know their family, they know their children, rather than having the person in the black robe make the decision who doesn't know the most intimate details of their life. And judges can only go by what evidence is presented. They're not allowed to go outside of that to make decisions. So it is preferred. And I got to do the 40-hour mediation training by the Florida Supreme Court. So I have a mediation background as well. And I do believe it's a very valuable tool. And that way, both people can have input in the situation I want to say it's a more relaxed setting, mediation. It is very serious, and hopefully we get to a formal decision. However, the courtroom, you don't get to be able to present evidence so easily if you're dealing with the rules of evidence.
So you're gonna follow the rules of evidence in your courtroom?
To the best of my ability. And there is the informal trial, though, which pro se litigants can do, which does relax it if both parties are pro se. So it does give them that ability. Now, family law, there is some case law about not having case concluding sanctions that will affect custody. So I believe that the judges do the best to follow the rules of evidence. However, there's also case law that, it needs to be heard on the merits. And some people may say that's relaxed. They may even say it's too relaxed. However, we're talking about children. We're not talking about, a car accident or something of that nature. This is children. And the law says in Nevada that we should hear the facts.
Mm-hmm.
So when it comes to domestic violence and someone is accusing either mom or dad, accusing each other of DV, with no evidence, no police report, no pictures, no bruising, but mom says dad's been beating her for years and he shouldn't get the kids. How would you handle a situation like that with absolutely no evidence, but the allegation of domestic violence is there?
Domestic violence is a very serious matter, and it's heartbreaking, and I take it very seriously. And I've dealt with a lot of domestic violence cases. And what I do with clients is I go through and, are there any pictures? Mm-hmm. Did you tell someone? Did you make any record at all? With social media, people share a lot of things. And, what we may not consider traditional evidence of police reports, arrests, convictions, trips to the hospital, there's other type of evidence because the law does prefer, and sometimes we might see it demands supporting evidence. And, the litigants are entitled to a trial and being put under oath and taking evidence. And testimony is evidence. That is a test. And credibility is at issue. So I would have to say very fact-driven. It's a very fact-driven situation. And domestic violence I take very seriously. And, I don't want to see anyone who didn't commit domestic violence, end up with, their record being blemished, so to speak. And, someone who's a survivor, they are, wanting to have some protection, which they richly deserve. And it's very difficult because it can be a he said, she said. And, our case law now says that, that's something that we can consider and reconsider, because people, it's a very difficult personal thing to talk about and to get the facts out. And so I think the law is coming along. Okay. It may not be there, however, it's coming along. And again, I will put my listening ears on and take the evidence of testimony if perhaps the documentation is not necessarily as you posed in that hypothetical.
Okay. We've court observed, we court observe, and we have seen some unruly litigants. We've seen them on Zoom where they're muted and they're just, jawing it on there, and the judge is trying to talk, and then you've got one in court, and we've seen argue. We've seen all kinds of things. How are you going to handle that kind of situation? Unruly litigants that are not listening, they're interrupting you.
That is a good question.
Get this one.
That?
You know, again, we're dealing with families
Mm-hmm.
and we're dealing with the most intimate, personal parts of someone's life. And, you know, emotion, I think, is part of the process. That being said, there's also a time that, you know, to be firm and dial it in. Because, you know, tears or an outburst, some emotion, you know, I anticipate that from the litigants. And I will give them the opportunity to get it together and move on with the hearing. And, you know, because I do believe that there's some compassion and grace should be brought to the bench. Again, we're talking about moms and dads. We're talking about husbands and wives and families. This is not, again, a car accident.
Mm-hmm.
So I believe, you know, give the folks the opportunity to bring it in. Give them a moment. That's the compassion, being firm, bring it in and let's have the hearing and get to a resolution for you.
Mm-hmm.
Making a decision. So that way they can get on with their lives.
How are you going to enforce your orders when mom and dad doesn't listen, or they just, you know, they're just making their own rules and they're not following anything that you say?
You know, that's one of the most important things judges do is enforce
Mm-hmm.
their own orders. And the law, however, is clear that if there is an issue with enforcement, the proper motion needs to be filed and it needs to be cited as to what part of the order is violated. And our revised statutes go into that. And it has to be pled correctly, which part of the order was violated, when was it violated, how was it violated. And then if that proper motion comes before me as a judge, then I can issue an order if the pleading is sufficient that there was an order, the other party violated the order, then I would set a hearing, an evidentiary hearing, and that's called an order to show cause why that party should not be held in contempt. Because without enforcing orders, there's no teeth. There's no teeth,
Mm-hmm.
and there's no accountability.
Mm-hmm.
And there needs to be accountability. Because when I talk to my clients, I say, I expect you to follow the order. The judge expects you to follow the order. And I ask my client, you're expecting the other party to follow the order, right? Yes, you're expected to follow the order. And that is how I anticipate to enforce orders.
How much weight would you give judicial discretion?
The proper weight that it deserves. And
Explain, please.
That's a difficult one.
it is. Because there is, I would say, some wiggle room or some breath.
Mm-hmm.
There's breath. And, you know, I think our case law gives us some boundaries of how far to go. Because I don't believe that it's okay to take discretion over the statutes, over the case law. Okay? There is a boundary. And I want to make decisions, and I anticipate that I will make decisions that are consistent so that the litigants can expect, you know, when I'm Judge Brewer, that they can expect this type of decision. I'm going to follow the law. I'm going to deliver this decision. And, you know, discretion will end where case law, you know, and our statutes are.
What about with TPRs? Is there, if someone, meets that threshold, which is a pretty high threshold,
Very high.
do you still have discretion to give that person one more chance, another 90 days, or another chance, or does the law force you to make that termination at that point?
Again, I believe in grace. And I believe that taking those facts into consideration, is that parent making an effort?
Mm-hmm.
What are the facts? And more commonly, termination of parental rights, the TPRs you mentioned, occur in juvenile courts. And so it's not as common with the domestic calendar. And that is what I anticipate that Department S will have as a domestic calendar. However, as you point out, there are the rare occasions. And with the juvenile calendars, you have resources. And the parents get to go to classes. And they get to work case plans. And if that comes before a domestic calendar, there are not the community resources that are available. And, so if the parent is making efforts on their own, absolutely those facts should be taken into consideration. Mm-hmm. And what's another 90 days because termination of parental rights means it does not exist.
It's so final. Yeah, it's terrible. I know it's necessary in some cases, but it is so devastating.
It's something that I do not take lightly. Mm-hmm. It should, and in my opinion, it should not be taken lightly.
Mm-hmm. How do you think the courts should handle parental alienation claims?
The facts should be considered, and sometimes it can be used as a ploy by one parent against another. However, again, people are when they file motions and come before the court, they're swearing that these facts and circumstances are true. Again, I believe that as a judge, I'm on a fact finding, and I should listen and read and take it seriously until someone gives me reason to not.
On that same subject, because people talk about that a lot.
Yes.
We see it all the time on our pages and stuff. Litigants talking about that, accusing the other side of alienation. What factors do you look for? What threshold has to be met? How do you determine that one side or the other is doing that?
I think it comes back to following court orders. So that is a baseline. Are the court orders being followed? Because if the pickups and drop-offs are occurring, if telephonic visitation is occurring, okay, so what else is happening? Are extracurriculars going rough? Or is the other parent showing up during the other parent's time during the extracurriculars? And, because sometimes one parent might say, well, the child didn't say hi. And I was actually in a courtroom where the judge took the non-custodial parent and said, why didn't you walk up and say hi? Because each parent has a responsibility to reach out to their child. And sure, it might feel a little uncomfortable or awkward. However, so what are the facts going on?
What if they're blaming the child where, well, my son doesn't want to see his father? What if they put it on the child, but maybe that's not really happening, but mom is using that as an excuse? My son doesn't want to see him, so she's keeping him away from the dad.
In my opinion, that is not a valid excuse, because parents tell their kids to put their shoes on, brush their teeth, go to school. And visiting the other parent, that is just something that is, does that parent not have control in their household, and appropriate control, because the parent is the one that's in charge. And also, it's a matter of encouraging the relationship of the child with the other parent. Both parents have a duty under Nevada law to do that. So I would want to query that parent perhaps a little more. So what do you mean? And, sometimes I've seen that, those were that parent's words, not the child's words. And that's why we have trials, and we don't permit hearsay under the rules of evidence.
How would you handle contempt of court claims? Were you willing to lock somebody up?
That's a last resort. That's truly a last resort. Again, we're dealing with these intimate parts of people's lives. I saw one judge once in 23 years for child support. And that by locking someone up, you're preventing them from going to their job. And then they might lose their job and not be able to pay their child support.
I have an alternative for that.
What is it?
If they work Monday through Friday, you lock them up over the weekend.
I think that's creative.
It's very creative.
It's very creative.
And it works. And you don't interrupt their job.
And because, you know what?
And they lose the time with their kid.
They should have thought about that because they're
Right.
not paying the child support.
Right.
Or if they work the weekend, then you lock them up during the week.
Well, and you know what? What did we talk about earlier? Following court orders. That's what the law anticipates is folks following court orders. However, that is a last resort. And, that is a creative solution and hopefully a deterrent, and hopefully that folks will follow the court orders so it doesn't get to that situation. But you know what? Again, considering the facts and circumstances, it may be necessary because if someone's not getting the message, it may be the necessary last resort.
Years ago, I told that to a judge, and he started to use it. He locked people up when they don't work.
Some judges
Problem solved.
Some of these people get away with not paying child support for years. And that's why I ask all the judges, how do you enforce your orders? Because when you have a judge that's allowing somebody to get away with not paying child support, when they have the money to pay it, and there's no sanctions, there's no jail, there's no consequences, what's the point of an order?
And you know what? The parent who is the recipient of that child support gets very frustrated, don't they?
Yeah.
And this money is for the child. And enforcing child support, now, it may be slower than we like. However, the district attorney child support division is quite effective. And, well, the good thing about that, it never goes away. Mm-hmm. So they have different tools they're able to do it without a cost to the parent who's receiving the child support. Now, again, going back to enforcing orders, the parent who is the recipient of the child support needs to file a motion and needs to plead properly and bring it before the court. And then as a judge, I will consider the appropriate remedy and relief for that parent. And, the arrearages, you have to do a schedule of arrearages. Mm-hmm. So certainly all the paperwork has to be done properly. And as a family court judge, there's the discretion and ability to render a decision. Mm-hmm. And the parents deserve that. Now, if someone is choosing not to and being sneaky, and maybe they're self-employed and there's other things going on with the facts and circumstances and they're hiding from, and that's why I say getting the district attorney child support division involved. That way, that obligation never goes away. Mm-hmm. And I've seen some happy ending stories that, finally child support was paid when children were in their 30s. Or
Oh my goodness.
because the child support division stayed on the case.
Yeah.
So to me, that is a happy ending for that family who needed the support, and the obligation was followed through with eventually. But as bring it before me, I will give it the consideration that it deserves and what is the resources that are available. And also by putting in the order, it can be executed by the district attorney. That way the litigant doesn't have to go through, hopefully, that next hoop. I have no control over what the rules are at the district attorney's office, but making it as, easy as possible with an order, if I can.
Right. Well, locking people up while they're not going to work gets rid of the argument that any attorney would say, Judge, if my client is locked up, they can't pay the child support. So you said, okay, when is your client not working? Oh, my client doesn't work on Mondays and Tuesdays. Okay, have them report to CCDC Monday and Tuesday. And that just kills the entire argument about if my client's locked up, my client can't pay child support. So I just want to put it on the record.
It's a very creative solution. And
it works.
And you know what? What I've seen work also is when a judge says, get $2,000, that's going to be the bail. And that's, starting the child support arrearages. I've seen that happen, not in my personal cases, but in other cases that I've been aware of.
And I've seen
it works.
I've seen one judge tell a litigant to take everything out your pocket and empty your wallet and give it to the other party for child support. I've seen that happen, and I thought that was funny too.
That's a creative solution, and it works.
It does work.
It works. It gets someone's attention, and again, I want the litigants, the folks that appear before me, to follow the court orders, because that is what the children deserve.
I saw that happen in Arizona, by the way. In Arizona Family Court, had them empty their wallets out right on the table. And I thought that was funny as heck.
That's very effective. I like that idea.
Yes.
Because you're not expecting it.
No, it's very unexpected.
Yeah, and I like the days off, go to jail.
Days off, you're in jail.
Yeah, you're not doing what you're supposed to be doing.
Well, Ms. Brewer, thank you so much for coming on the program. We really appreciate you. Mark is going to zoom in on you, and this is your moment to say your closing remarks. Come to my website, blah, blah, blah. I need your vote, or whatever we haven't covered, you could cover it during that time.
Thank you. Again, my name is Kristine Brewer. I am a candidate for Family District Court, Department S, and I would appreciate your vote. The primary is June 9th, and if I get 50% of the vote plus one, then there will be no general election. I would like you to know that I have had the opportunity to serve clients from all socioeconomic walks of life, from legal aid, to the 1%. I have a depth and breadth and knowledge that I believe would be very beneficial. And I care deeply about our community and the families in the community. My email is Kristine Brewer 4 judge@gmail.com. And my website should be the same very soon. And I look forward to meeting you out in the community. And if you have any questions, please feel free to contact me. Thank you.
Thank you so much, Ms. Brewer.
Thank you,
Thank
Steve.
you. Thank you, Ms. Phillips. Folks, that's Kristine Brewer, candidate for Clark County District Court Family Division Department S. And we hope that this program is informative and educated. for you. So when you go to the voting booth, you will know exactly who to vote for. And this candidate has a wealth of knowledge and experience, and she will serve this community well. This is Steve Sampson, Stephanie Phillips with Veterans in Politics. Until next time.